Welcome to Plan On It.
Hello, everyone, and welcome back to Plan On It with attorney Christopher E. Botti, board-certified specialist in estate planning, trust, and probate law. Chris has more than 30 years of experience helping individuals and families plan for long-term care and protect what they've built. My name's Sean O'Connor, and today Chris and I are continuing our Ask Chris Anything series. In these episodes, we answer real questions about estate planning. And if you have a question you'd like Chris to answer on a future episode, send us an email at info@boddylaw.com. We appreciate everyone who has submitted questions so far. Hey, Chris, how are you?
Great, Sean. Good to see you.
It's good to see you too. My first question is just a basic one, and that is, what is the difference between a trustee and an executor?
That's a great question. We get it all the time. It's essentially the same function. It's the financial role. So in a trust, when you designate someone to be the manager of the trust assets, that's called your trustee. And in a will, that same function would be called your executor. So we don't use the term trustee in the context of a will, but essentially they're the same job. It's the person you designated in charge of the financial aspects of either the will or the trust. So it's essentially the same thing, and it should be the same person.
Got it. The next question that was submitted is, it's pretty straightforward. When I die, what happens then? Why does trust administration cost? But listen, if you know the answer to that first one, when I die, what happens then? I'd love to know. Put it in the email. And then,
well, that's a philosophical question. That's
why does trust administration cost money?
Well, it doesn't necessarily have to cost money. Okay. So unlike wills that are probated in California, and that definitely costs lots of money, a trust administration, it's up to the successor trustee, the person you designate as the one responsible for unwinding the trust, to determine whether or not they feel like they need help. Because a lot of people feel overwhelmed after someone has died, and they don't know what to do next. And so our office actually has a trust administration department where we can guide trustees from start to finish and get them across that finish line. And we always tell our successor trustees who reach out to us after someone has passed on, like, we say, look, you don't absolutely need an attorney or an accountant for that matter. If you feel comfortable doing it yourself, there's nothing in the law that says you must hire a lawyer. But oftentimes I feel like people are overwhelmed. And so we provide a roadmap. And so we have a process in which, when we get a call like that, we send the successor trustee out a memorandum explaining what they're supposed to be doing and thinking about. That'll educate them. And based upon their review of that document, they may or may not decide to seek further help from us, and we will absolutely provide further help. And that's where the cost potentially can come in. The successor trustee has the right to use trust assets to get help. For example, cleaning out the garage. That could be a very difficult chore. And do you want to be doing that yourself or hire someone to do that? Same with accounting, taxes. And so you have a final tax return that's due. You want to be doing your own taxes or hire a CPA. It's the same with a lawyer. So I often encourage people to get help because you have the right to use those resources, and it makes you feel more comfortable knowing that someone's holding your hand. So not required, but generally recommended.
Yeah, well, and like you said, there's money there typically to cover those costs. So
right, and it's nothing like the expense associated with a probate. Like, you compare the administration expenses versus a probate, it's a night and day difference.
Yeah, I've heard, and we've talked about some of that in the past. This next question comes from someone who is a trustee. They're the trustee of their brother's trust, evidently, and they want to know, what do I need to know for when he dies? So I'm assuming, okay, my brother has passed. What are the first steps he needs to take?
Well, they're going to want to take a look at the trust and read it, right? And make sure they understand what they're in for, what the responsibilities are. And then from there, they have things they must do under California law. For example, a trust administration is supposed to be fully transparent. So the beneficiaries, those named in the trust, are entitled to be made aware of what's going on. And that includes providing a copy of the trust to the beneficiaries, along with letting them know that, one day they're going to be getting an inheritance once the administration process has been completed. So transparency is the name of the game. And so what a trustee needs to think about is, okay, I can't just sit on my hands. I need to kind of move forward and do things. And so that's typically where we get that call when they start thinking about, what do I need to do? And they'll reach out to us and we provide that roadmap for them.
Got it. This question, this is interesting. I was wondering about, updates and that sort of thing. This listener has said they did their trust, executed their trust back in 2005. And they're wondering if there have been any updates in the law that require me to update my trust if I don't have any other changes. So the trust in their eyes is all good, but are there new laws in place that might need to be, that might require some kind of an edit?
Possibly. Okay. From a client perspective, this question comes up often, like how trust in and of itself, because it's 20 plus years old, doesn't render the trust invalid. You could theoretically have a trust that's 100 years old and be perfectly fine. But the driver for amendments from a client perspective is changing who's in charge or changing who gets what. Absent that, the law does change, and it does on a somewhat regular basis. Every year there's revisions to the trust law and cases come down that potentially impact what we do going forward. But the good news is with these changes that typically occur, it's exceptionally rare that a change in a law would be require you to update a specific document. Because it's grandfathered in. And so typically what happens is if you're going to change it for another reason, at that point, the person who's been hired to do the change, the lawyer, would then take into consideration what is of change in the law since this trust was originally established. And they would bake into the trust the new updated provisions in the law to deal with the current law changes. And so it's like upgrading a house. Like if you bought a house in 1960, in 2026, you're trying to replace your kitchen. Well, you're not going to be able to use 1960 codes. You're going to have to use the current building codes, and so it's kind of similar to that with the law. And so, the biggest change since that trust was created was the amount you can leave estate tax free. So that number is called your estate tax exemption, sitting at $15 million. So for people who have had baked into their documents planning to get around the estate tax issue, that may no longer be required. That's the biggest potential change that's occurred since then. And the only way they're going to find out if they need to do that would be, unless they are truly savvy and can understand their paperwork, is to reach out to, if we drafted it, for example, us, to say, do I need to change anything here? That's what we typically want our clients to do, because better safe than sorry. Just ask the lawyer who drafted it.
Yeah, that makes sense. I have a question about that, the grandfathered in and that sort of thing. If, let's say, okay, just using this as a hypothetical, the trust was created in 2005 and, 20 years have passed, and as like, it's my trust and my brother was the executor, let's say, or the trustee, he's passed. I want to change, I need to make some changes, right? So I go to you, Chris, and we're going into the document to make these changes. Are you required then to make any changes that might have happened in the law, to sort of bring it into line? I'm thinking here, maybe I'm overthinking it, but the idea that maybe a law has changed that isn't as beneficial as it was, might have been more in the trust's favor, or my family's favor with the old law. Do you know what I'm getting at there? Is that
Yeah, I mean, so when this is a common question. So if you're changing successor trustees, for example, you're moving a brother and replacing with a child, for example, which is the most common amendment our clients do because their kids are younger typically when they establish their trust.
Yeah.
It's not strictly a word processing exercise. I can't just take what they signed in 2005, for example, and just use Microsoft Word and do find and replace and reprint. I'm under an obligation to make sure that all the significant law changes that affect their particular plan are
up to
going to be
code,
incorporated into. Yes, correct. And so if there's a change that is detrimental and we don't have to include it potentially, of course, that'll be up to the attorney to decide. But the bottom line is that, we're always trying to give our clients the latest and greatest of what we do and what's out there. We're always updating our paperwork to deal with changes in the law and developments. And so when a client comes to us with a trust that old and they're changing trustees, they're going to get what they call a restatement, which is a complete update of their documents where they don't have to go back and forth between two sets of documents. And so that's typically how we do it.
I see. Good clarification. This next question from the point of view of someone whose aunt died and she had my brother as her successor trustee, and the questioner is the alternate trustee. So the question now, what's going on is the brother doesn't want anything to do with the trustee job duties. How does this alternate trustee step in? Are there specific steps to trigger that?
Typically in the trust, that would be covered, be baked into the documents. In other words, the trustee can resign or decline to act, and then the alternate successor trustee. So it'd be something created in writing where the trustee basically says, I decline to act if they haven't started doing anything. And then the new successor would sign something saying, I accept the role as trustee. And you would have them sign that. And that way they can step in and act on behalf of the trust because the first one is clearly resigned. Or if they decline to act. But if they've started the work and they get into it and they're like, I'm in over my head, it's just too much, you can resign. It's a similar process. And the bottom line is you want to document that. It's not complicated, but just document it.
The question here is, what happens when someone dies and nobody can get a hold of the successor trustee?
What happens then? Well, okay, so that brings up a good point. When you're designing your trust, you want to make sure your successor trustee is all in and doing the job, right?
Okay.
And you want to keep records of, maybe perhaps provide them a copy of the trust. But if a trustee disappears and they cannot be located, there's going to be provisions in the trust that allows the beneficiaries or the alternate trustee, for example, whoever's got a vested interest in the outcome can step up and actually make that happen. It may require a court petition, unfortunately, because the person can't be located, but there's provisions or mechanisms that allow that to happen, that would just not languish there indefinitely because the trustee disappeared.
Right.
There's typically language in the trust that allows that transfer to occur without the need to locate someone if they've gone off the grid, for example.
Yeah. Well, I'm assuming that, a certain amount of time needs to pass or certain steps need to be made to locate them. But also in the case of the alternate trustee, they are in the loop that they are an alternate trustee, presumably, right? That they're...
Yeah, they should be. I mean, in other words, like, this is an important function. Before you choose a trustee, you want to reach out to them and say, are you willing to do this for me?
Right.
And so they're aware that one day they may be called upon to act. And that would be true of any alternate successor trustee that you put into your documents, alerting them that you're a backup, you're plan B, or you may not call it plan B, but whatever, you're the second in command. And then let them know that could come their way.
Yeah.
It could come their way.
Okay. So here's someone who's written in and they're in the process of getting a divorce. They want to know if their trust automatically becomes invalid. Is there something that both parties have to sign?
Well, it's not automatic. What happens when someone's going through a divorce is the assets are frozen. This is a family law issue, essentially. And basically, status quo is being maintained. No asset transfers can occur until this divorce is finalized. So there's a freeze on transfers absent a court order. But you're going to want to either together, if it's a joint trust, unilaterally revoke the trust, because you're not going to want your soon-to-be ex-spouse inheriting everything you've worked your entire life to accumulate, and be potentially in charge of making medical decisions for you and financial decisions for you. So if the other spouse is unwilling to cooperate, or if you're an individual, then you can unilaterally revoke your trust and put in place a new plan to deal with the issues of who takes over if you're incapacitated and where your stuff goes when you pass on. So you don't want to sit there and just ignore the fact that you have an existing estate plan. If you're going through a divorce, you want to get rid of it.
Mm-hmm. Well, this question, I mean, it implies that there was I think you used is it joint trust? I mean, it's possible too that I could go into a marriage with a pre-existing trust that is just something I set up for my kids, etc. Is that
right?
And then if I'm going through a divorce, that wouldn't be an issue. I mean, I guess it would have to have been listed as something in a prenup that's a thing that exists and etc. Or
well, that's a great question, because there are situations where married people, particularly in blended families, might come into the relationship with an existing individual trust. And there's no requirement just because you're married, we have to do a joint trust. And so what you're going to want to do is you're not going to revoke that necessarily, but you may very likely amend it because you probably have baked into the documents appointed your spouse as a potential successor trustee, appointed your spouse soon to be ex as a potential beneficiary,
Okay.
and also in charge of potentially healthcare decisions. So you're going to want to look at that and say, well, that's not the team I want anymore. And you're going to not revoke, because you don't have to do that because it's not a joint trust.
Right. Just an amendment.
In the case of a married person, you just amend it. Correct.
We have time for one more question here. This one is, I think, kind of basic. It's like, how long is a trust still active after someone dies?
Yeah, by the way, basic questions are okay, because a lot of people, for me, these are simple questions and I deal with them all the time. But the fact that people are asking these questions is important to me, because the whole purpose of doing this Ask Me Anything podcast, or these, is to educate people and to encourage our clients to reach out to us. So the bottom line is this: look at the trust, because you can have a trust continue on after you die for various reasons. For example, managing money on behalf of minor children, where the kids are too young to handle all the money at once. You're going to want to keep that trust active until they've reached a point where they can handle it themselves. And so that would be a reason why the trust would carry on further after you died. But absent something like that, it's when the last asset leaves the trust is when the trust basically goes away. There's no need to file anything with any courts saying this trust is now closed. It's just a matter of taking the assets out of it. And once the last asset leaves it, it essentially dies on the vine.
Yeah. Oh, that makes sense. Okay. Yeah, but the whole, if there are provisions in the trust for, hey, who knows when you're going to die, right? That
Right.
my kid's 13 at the time, I'm like, all right, there's some accounting made for eventually when they're 18, they get the rest of the money or the assets or whatever it might be. So that makes sense. So it's all.
Yeah. And that's very common to have these provisions in there to deal with people who, if all the money came at once, you'd be doing more harm than good. And there's lots of reasons why that question could be answered. Yes, it'd be doing more harm than good. And so you would extend the trust for that purpose.
Great. Well, Chris, thanks for your time. Thanks for answering these questions for the folks that sent them in. As always, I enjoyed talking to you, and I'll see you again soon, I'm sure.
I appreciate you. Take care, Sean. Good seeing you. And keep the questions coming, guys. I love them.
Yeah, for sure. That's it for today's episode of Plan on It with attorney Christopher Botti. If you have a question you'd like Chris to answer in a future Ask Chris Anything episode, send an email at info@boddylaw.com. That's info@boddylaw.com. And to access more resources, including the 2026 Medi-Cal ebook and upcoming estate planning workshops, visit boddylaw.com. Thanks for listening. I'm Sean O'Connor, and don't forget to leave a review, and maybe share this episode with someone in your world who needs information about estate planning. Have a great day.
If you're enjoying Plan on It, be sure to subscribe, leave us a 5-star review, and like the post. Share or tag friends and family who could benefit from clear, practical estate planning guidance.